There is a sound every prosecutor dreams of hearing in a courtroom. It is not applause, it is not cheering. Those things almost never happen in professional settings. The sound prosecutors long for is silence, complete, absolute silence, the kind that follows a revelation so shocking that everyone in the room stops breathing at once. I heard that silence yesterday, and it was preceded by something I have never encountered in more than 30 years of courtroom work. A judge audibly gasping, not a quiet intake of breath, a full, unmistakable gasp that echoed through the room. Why? Because the prosecutor had just spoken 4 words that changed everything. His wife wore a wire. The trial had already been underway for 3 weeks. The charges, bank fraud, false statements, wire fraud, a standard white-collar case. The defendant, a real estate developer, accused of submitting inflated property valuations to secure loans. The prosecution had documents, emails, financial records, solid evidence, but much of it was circumstantial. This was the type of case where the defense could argue innocent mistakes, reliance on professionals, or the difficulty of proving intent. The jury had been attentive, taking careful notes. The case could have gone either way. Then came yesterday afternoon. The prosecution was in the middle of presenting their case. Bank executives, accountants, and real estate appraisers had already testified, establishing that the valuations were false and the banks had relied on them. The defense had cross-examined effectively, arguing that appraisals are subjective, experts sometimes disagree, and the defendant had no reason to doubt his team. Reasonable doubt was very much in play. The prosecutor stood to call the next witness. The United States calls Rebecca Martinez. A woman in her early 40s entered from the back of the courtroom, professionally dressed, composed. She walked to the witness stand, was sworn in, and took her seat. The prosecutor began with routine questions: her name, occupation, how long she had lived in the area. She answered calmly. Then came the pivotal question. Ms. Martinez, what is your relationship to the defendant? She looked directly at him for the first time and said, "He's my husband." The courtroom shifted. People stirred in their seats. The defense attorney's head snapped up, clearly caught off guard. Spousal testimony is complicated. Spouses usually cannot be compelled to testify against each other, but if a spouse appears voluntarily, it signals something extraordinary. The prosecutor let the moment breathe. "Are you testifying voluntarily?" she asked. "Yes." "Has anyone forced you or pressured you to testify?" "No." "Do you understand that you have the right to refuse to testify against your husband?" "Yes." "And you are choosing to testify anyway?" "Yes." The prosecutor returned to the evidence table and held up a small device, about the size of a key fob, for the jury to see. "Ms. Martinez, do you recognize this item?" "Yes," she replied. "What is it?" "It is a digital audio recorder I wore for 6 months, documenting conversations with my husband about his business dealings." That was when the judge gasped audibly. I was in the 3rd row and heard it clearly, so did everyone else. Even a judge who has presided over hundreds of trials was not expecting this. The defendant froze. His attorney jumped to object, but the prosecutor was prepared. Marital privilege does not apply when a spouse voluntarily waives it. The recordings were made legally with the consent of one party. The wife had independently approached the FBI. No deals, no promises, no immunity. The judge overruled the objections. "Why did you decide to record your conversations with your husband?" the prosecutor asked. "Because I discovered he was committing fraud, and I knew that if I did not document it, he would lie about it later. He lies about everything." The defendant closed his eyes. His lawyer scribbled notes frantically. "How many conversations did you record?" "Approximately 60 over 6 months." "And what did these conversations contain?" They contained him admitting he knew the valuations were inflated, discussing how to hide it from the banks, and coaching me on what to say if anyone asked questions. The prosecutor requested to play portions of the recordings for the jury. The judge allowed it. The first clip: a conversation in what sounded like a car. The defendant's voice was clear. He discussed a low appraisal. It does not matter what the appraisal says. We tell the bank what we need the value to be. They never check. When his wife asked if that wasn't fraud, he laughed. Only if you get caught, and we are not going to get caught because everyone does this. 5 more clips followed, each more damning than the last. Admissions of manipulation, instructions to lie to investigators, discussions of shell companies to hide assets. The jury was captivated. Some shook their heads. One juror covered her mouth. This was no longer circumstantial. This was direct evidence, in his own voice, confessing to every element of the crime. The defense attempted to recover. The attorney asked why she remained married if she suspected he was committing crimes. She replied she had filed for divorce 3 months prior. Why record him? Because she had witnessed the harm caused by his fraud and refused to be complicit. Was she angry? Yes. But the recordings were real. Their context clear. From a legal perspective, this testimony was devastating. In fraud cases, knowledge and intent are often the hardest elements to prove. Prosecutors typically rely on circumstantial evidence, showing access to true numbers, attendance at meetings, inferring intent. But here, no inference was necessary. The defendant admitted his intent and knowledge in private conversations where he had no reason to lie. Direct evidence, clear, unambiguous. Beyond the legal consequences, consider the personal betrayal. His wife wore a wire for 6 months, documenting every moment of trust. She acted normally, asked questions, recorded everything, and brought it to the FBI. The psychological toll was immense. Yet she acted out of principle, stopping harm, exposing the fraud, refusing to protect a criminal, even her husband. Legally, this was permissible. Marital privilege can be waived voluntarily by the spouse. Privilege does not cover ongoing or future crimes. The wife was a one-party consent to the recordings. No warrants were required. She had every legal right to cooperate. The prosecution rested shortly after her testimony. The defense was cornered. How could they explain statements like, "We tell the bank what we need the value to be, they never check," or laughing, "Only if you get caught"? They could not. They rested without calling witnesses. Anything further would only highlight the recording's power. In closing arguments, the prosecutor reminded the jury, "Ladies and gentlemen, you do not have to take my word for what the defendant knew. Listen to his own words, admitting everything. Listen to him laugh and say, 'Only if you get caught.' Those words speak for themselves." The jury sat in stunned silence. Several stared at the defendant with visible disgust. The defense attempted to argue bias or exaggeration, but the recordings spoke for themselves. Deliberations began 3 hours ago. Given the clarity of the evidence, a guilty verdict seems inevitable. When it comes, the defendant will face the reality that his own wife provided the evidence that convicted him. Since yesterday, I have been reflecting on the judge's gasp, the silence, and the wife's testimony. She was not vengeful. She was weary, tired of lies, fraud, complicity. She chose to stop protecting a criminal and to do what was right. That choice destroyed her marriage but prevented further harm. The law supports her actions. The defendant, at every turn, chose deception over honesty, even with the person closest to him. That miscalculation will cost him everything. What would you do if you discovered your spouse was committing serious crimes? Protect them or take action like she did? I want to hear your thoughts. I will update when the verdict is announced. If you want, I can also create a highly optimized, high CTR YouTube version of this script with punchy time stamps, hooks, and segment breaks, so it reads perfectly, for an investigative courtroom video while keeping the suspense and drama intact. Do you want me to do that next?